Good day, sir and batchmates. I'm Ivy and S. Bumanlag from 4G1BS Criminology. I'm going to discuss what I learned in the subject of criminal procedure and court testimony for my final examination. I'm going to discuss the topic of Rule 119 to up to Rule 126. So first, let us define Rule 119, which is trial. It is the examination before a competent tribunal of the facts. Put in the issue for the purpose of determining such issues, meaning to say, in the trial where the accused is able to ask some question by the court relating to the issue. The aim of a trial is to determine the innocent or the guilt of a accused and giving them a chance to prove themselves in the court. After a plea of not guilty, the accused shall have at least 15 days to prepare for trial. Uh, the trial shall commence within 30 days from the receipt of the pre-trial order. Also, if you are familiar with the word of continuous trial, from the word itself, continuous, meaning once a trial commence, shall continue day to day until it's terminated. And the entire trial period exceeds 180 days from the first day, and the court must give their judgment within 90 days counted from the time of submission of the cases of resolution. Next, under the Rule 119, we discussing here the absent witness and the unavailable witness. Whereas the witness is absent cannot determine or unknown by due diligence, meaning the court doesn't have an idea why he or she not showing up in the trial. Unlike sa unavailable witness, whenever his whereabouts are known, but his presence for trial cannot be obtained by due diligence. So according to the definition, the witness is already known, but his presence in the court what you call that, because absent, I not absent because of some reason, but the court is already aware about that. And after the trial, the court shall amend the judgment. I have learned also another terminologies in a Rule 119, which is the state witness. A state witness defined as any person who has witness or has knowledge or information on the commission of crime and has testified or testifying or about to testify before any judicial or quasi-judicial body or before any investigating authority. This state witness is under Republic Act 6981. Next topic will be the Rule 120, judgment. Judgment defined as the court will determine if the accused is guilty or not guilty on the offense charge, imposing on him of the proper penalty and civil liability. It must be written in official language, personally and directly prepared by the judge and signed by him. And then, if the accused is acquittal, then it shall state that the prosecutor failed to prove the guilt of the accused beyond reasonable doubts. Next is the variance of doctrine. This doctrine is the offense charged in the accused or information that already proved, but if the court seeing that there is a circumstances that is absent, then the charge will be changed. The accused or the information will be changed into a suitable penalty on the felony he or she did. Next is the promulgation of judgment. The judgment is promulgated by reading it in the presence of the accused and any judge of the court in which it was rendered. The court promulgating the judgment shall have authority to accept the notice of appeal if the decision the court convicting the accused change the nature of the offense from non-bailable to bailable. The application for bail can only be filed and resolved by the appellate court. No? Moving on, let us proceed to modifications of judgment. Upon motion of the accused, the conviction modified or set aside before it becomes final or before appeals is perfected. After a judgment has become final, it shall be entered in accordance with the rule of 36. The elements of the final judgment order shall be entered by the clerk. If the date of the finality If the date is penalty of the judgment of the final order shall be deemed to the date of its entry, and the record shall contain the dispositive part of the judgment, signed with the clerk, with a certification, and become final and executory rather. Moving on and proceed in Rule 121, which is the new trial or the reconsideration. Let us first let us first know the new trial. We're able to understand easily the Rule 121. A new trial whereby the accused on his own motion or at the initiative of the court, but when the consent of the accused is allowed to present additional evidence in support of his defense after a judgment of convicted has already been rendered, But before a judgment become final, um, um, the court shall grant reconsideration on the around of errors of law or fact in the judgment, which requires no further proceeding. So the new trial and reconsideration defined as any time before a judgment of conviction becomes final. The court may, on motion of the accused or at its own instances, but with the consent of the accused, because only the accused can be filed a new trial and not the prosecutor, because the accused replace on the double jeopardy. Double jeopardy meaning to say the accused or the information cannot be charged with the same felony at the same time. Then, after the new trial, let us proceed to Rule 122 or the appeal. Appeal defined as a proceeding for review by which the whole case is transferred to a higher court for a final determination. It must be filed within 15 days from promulgation of judgment. Then, guys, remember that any party may appeal from judgment or a final order unless the accused will be placed in double jeopardy. You can file your appeal into the MTC, into the RTC, and CA if a penalty imposed is reclusion perpetua or life imprisonment. And the appealee may waive his right to a notice that an appeal has been taken or send a waiver of notice to a court. And during the new trial, the lower court loses their jurisdiction over the case because a higher court now takes charge of it. In addition, if the appeal must be taken within 15 days from the promulgation of the judgment or from notice of the final order appealed from. We're about done in Rule 123. So now let us proceed to Rule 124, which is a procedure in the Court of Appeals. We distinguish first here the difference between appellant and the appealee. If the party appealing the case shall be called the appellant. The appellant or his counsel can send notice from the clerk of the Court of Appeals within 30 days from the receipt, while the appealee, when the evidence adverse the party, called appealee. After the period of time of appellant, appealee shall file 7 copies of the brief of the appealee, with the clerk of court, which shall be accompanied by the proof of service of 2 copies thereof upon the appellant within 20 days from the receipt of the brief, and um, from for the receipt of the brief of the appealee. Yun. And now, we're going to discuss the Rule 125, which is the procedure in Supreme Court. When they say our Supreme Court, impact in equally divided in opinion, or the necessary majority cannot be had, or whether to acquit the appellant. The case shall again be deliberated upon, and if no decision is reached after the redeliberation, the judgment on conviction of the lower court shall be reversed and the accused acquitted, according naman sa Rule 126 Section 3. That would be all in Rule 125, and um, the last topic I'm going to discuss is the Rule 126, or search and seizure. Before conducting this search and seizure, importantly, the person in charge or the officers have a search warrant, an order in writing issue in the name of the people of the Philippines, signed by the judge and direct to a peace officer, commanding him to search for a personal property according doon sa search warrant, no, described therein, and bring it before the count according to Rule 126 Section 1. On conducting search, the judge, before issuing the warrant, personally examine in the form of searching questions and answers, in writing and under oath, the complainant and the witness. He may produce on facts personally known to them, and attach to the record their sworn statements, no, together with the affidavits submitted according to Rule 126 Section 5. And the time needed on the conducting a search, the warrant must be direct that it's be served in the daytime, unless the affidavit assert that the property is on the person or in the place ordered to be searched, in which case is direction may be inserted that it be served at any time of the day or night. Also, I have learned some terminologies in this rule, such as one of them are scatter warrant. No, this search warrant issued for more than one specific offense. No, this kind of warrant is void and not allowed. No, next is the probable cause. This probable cause is supported by facts and circumstances, as will warrant a cautions man in the beliefs that his actions and the means in prosecuting it are legally just and proper. That would be all. And before I end this video, I would like to say thank you, sir, for teaching us for this first semester, and greet you advance Merry Christmas and Happy New Year po. That would be all. Thank you.